Hello, everyone. We are going to talk today about the competence to testify in court. So, competencies in criminal processes. Decisional competence is the competence to make a particular decision in court. Particularly, the most common example is the decision to make a decision on a plea bargain and to understand what the plea bargain actually entails. In some situations, defendants are not able to make decisions on their own behalf. This is the concept called parens patre. It means state as parent. It is when the state has the ability to make decisions for a person that cannot make these decisions for themselves. Western societies believe in the concept that humans deserve respect and individuality. Competencies assessed in criminal processes include important decisional competencies in criminal cases, specifically, are competence to consent to search and seizure, competence to exercise and waive the right to avoid self-incrimination, competence to enter a plea, competence to waive the right to an attorney and represent oneself, and competence to refuse the insanity defense. So then there are two that are part decisional competence and part adjudicative competence, and that is competence to testify and the competence to be executed. Now let's talk a little bit about competence to testify and legal requirements. So courts have usually believe that people that are incapable of remembering, incapable of reporting what they have seen, or incapable of understanding the importance of remembering and reporting should not be allowed to testify. Testimonial competence can be addressed for anybody testifying. This means that it's not just the defendant that is possibly going to be tested for this. A related topic that is addressed often with testimonial competence is the credibility of the witness and their testimony. This is because testimony is very influential on jurors. Therefore, it is important that it is an accurate testimony. So some of the legal requirements, most courts have ruled until about 1970 that children under the age of 10 or 14 were automatically incompetent to testify. And if they did testify, they must be proved competent. People with significant impairments, such as mental disabilities, were banned from testifying pre-modern times. But modern times, nowadays, the rule is that everyone is presumed competent to testify. And again, if there are issues with this, they must be raised and addressed before they can testify. Rule 601, which is not on here, but we'll talk a little bit about it. From the Federal Rules of Evidence, 1975, states that every person is competent to be a witness unless their testimony is irrelevant, likely misleading, or likely untruthful. So then there was a study done by Lewisol and Mueller that they found that neither immaturity nor mental or psychological disabilities, use of drugs or alcohol, signify that a witness is unable to testify with relevant evidence, meaning that they are all still presumed competent to testify. So few states to date set an age limit for competency, but the most common individuals to trigger this testimonial competence are children, people with mental illnesses, people with intellectual disabilities, people with mental illnesses, and people that have abused substances. Witnesses that have been abused and are testifying against their abuser are considered irrebuttably presumed to be competent. So next we'll talk about observation. This is one of the things that is assessed in the court when we are talking about the competence to testify. So a child or a person without mental disability, vision and hearing deficit, testimony will be sufficient, and children seem to have trouble remembering unfamiliar disguised faces and complex scenes. But this is known to advance with age. Children may have difficulty understanding the meaning of important and meaningful conversations, but on the other hand, children can register an event without even understanding it. So, memory and suggestibility. The ability to remember what has been observed is just as important as what has actually been observed. Suggestibility can affect the memory of what has been observed. So this just basically means that people, third parties, outsiders giving misleading information or false information can affect what somebody remembers or what they recall that they remember. So Lamb and colleagues state that age is the most important determinant of children's memory capacity. Most children except the youngest children, typically have a good enough memory to pass minimal requirements when being evaluated for testimonial competence. When testing memory ability, there are two different types of memory that are being evaluated. And the two memories are recognition memory and recall memory. So recognition memory is would be like, can you recognize this person or place, the picture or something of that such? And recall memory would be more free recall, as in, can you describe such person, place, or event? It seems that when it comes to recognition tasks, children ages 3 to 4 do just as well as adults. Example of recognition task would be like, again, like I said, showing a picture and seeing if a child or anybody can recognize a particular face or scene or event. So, on the contrary, children as old as 9 seem to make more errors than adults when asked to identify perpetrators in a lineup. Younger children may also place familiar people at an event that this person was never actually at. Recall memory seems to need more sophisticated or advanced cognitive processes, and children find it more challenging to describe past events than recent ones. So children being able to recall significant memories are contributed to two things: the time and how many different versions have been suggested by third parties. When we're talking about time, we're talking about the time between the event and when they are being asked to recall it. If it is a short enough time, children seem to do just as well as adults. There is a study that has found that the percentage of inaccurate information provided by children ages 6 to 9 doubled from 9% the day after to 18% at 5 months after. A way to decrease memory decay is to obtain an interview fairly quickly after an event has occurred. Open-ended questions are ideal in forensic interviews, and younger children do better at recalling when they receive direct cues and questions, but this is known to jeopardize the accuracy of the testimony. Memory counting by children may be suggested intentionally or unintentionally when adults help children make sense of the event to be recalled. It is known that younger children are more likely to agree with such suggestions when they are made by authority figures. Questions are highly leading, detailed, incriminating, repeated over a long period of time. So there was a study done by Haggard. I won't go into too much detail. Haggard et al. It basically included a video shown to children, a girl being approached by a neighbor but not touched. The interviewers then, after it was over, said that the girl was in fact touched and assaulted by the man or the neighbor. And the children, about 29% of them did actually report that the neighbor did assault the girl. And that just goes to show suggestibility. So children's behavior is influenced by their perceptions of what the immediate adults around them's expectations are. The ability to communicate. If the event in question cannot be communicated meaningfully, then the information is useless. In other words, it is important for the person to be able to understand complex events and able to order them in time and space for legal importance. When dealing with cases of sexual abuse, children may be assessed in their comprehension of sexual terms relevant to the case. It is said that by age 5, children can understand most grammar rules of their native language and can construct and speak adult-like sentences, meaning that they're able to communicate events. Children ages 3 to 4 have the capacity to take and put themselves in someone else's shoes if the task is simple enough. Modern day courts are not too worried with most of these previous concerns. They are most worried now about the truthfulness of the testimony, not so much age. There are steps that can be taken to help a child's testimony become more understandable. A lot of research has been done with like dolls. Can you show me on a doll? Or is this what happened? And you do the actions on a doll or whatever the chance or whatever the case may be, and the child can understand that way better. So conclusions. Children as young as 5 can observe events, remember them accurately for a pretty long period of time. Children as young as 5 can communicate their understanding of how long important truthfulness is. 3, children young as 5 have difficulty with long-term memory, resisting suggestions from others, and being able to appropriately communicate what they have seen. The courtroom is also known to be a scary and unsettling place for children, but these can seem to be managed by the use of testimony on screens and TV monitors. This just provides a distance, a space between the defendant and the witness in the courtroom. And now we're going to go back because I didn't go to moral development, the truth and falsity. Sorry about that. So pre-modern times, children witnesses were asked if they believed in God, if they knew the consequences of telling a lie in court. Children as young as preschool can distinguish between a lie and the truth. There's a small percent of children that get their definition of truth and lie from parental direction. So that means that most children come up with their own definition of a truth and lie, which is good. Asking a child about the difference between a truth and a lie will reveal developmental disabilities rather than their intentions on actually telling the truth or not. So in some cases, it's kind of, I don't want to say irrelevant, but in a way it is. Okay, so then we have the conclusions that we just went over. And these are just guidelines for evaluations, just some things to keep in consideration. If evaluation is done, the courts are concerned with observation, memory, and communication skills and the moral capacity. Psychological evaluators can also be helpful in informing the court of the witness's genuineness and if they seem to have been suggested by others. A child may have problems realizing a situation or event as deviant. Evaluators must try to avoid creating memories for witnesses. And this is a short, about 7-minute video I have about ways that children can testify outside of court, again, providing that space between the courtroom setting and the defendant or who they're testifying against. And the discussion question I have are, what steps could be taken to help witnesses accurately remember the events in question without providing suggestibility? And are there steps that could be taken to help children specifically? So all adults and then just children specifically. Okay, guys, I want to thank you so much for watching my lecture on competence to testify in court.